most of you in here are working pretty hard in order to have a long career, right? It's not something you're doing just to do for 6 months or a year or something like that. And so I really don't want to be getting the call that somebody here has made a misstep and we're looking at having to send you on your way. Because I can tell you, let me back up one step. In addition to being general counsel for you guys, I do a lot of work with Endurus, which is the risk pool for special purpose districts across the state, because that encompasses most of the fire districts. And, you know, there just is so little room. If you mess up, the liability is such that something bad is going to happen to you. And I don't want to see all of you having worked so hard and then be on your way out the door for something that doesn't need to happen. So I really want to try and make sure, like I do every year, help you guys know. I mean, we all know that you're not supposed to harass people, right? We all know you're not supposed to discriminate against people. And yet I have a full-time job. So why is that? Because we don't always see it when it's happening. And I need you guys to know what it is so that you don't make a mistake. I had somebody ask me one time, well, Michelle, how do I know where that line is? And I want to cross the line, but how do I know where it is? You don't even have to get close to the line. Okay? You don't have to get with your toes hanging over. So just, there's lots of really great jokes you can tell that don't have anything to do with race or religion or things like that, gender. So, let me see if I can, remember it's up there. See if I can give you good information today. 3 basic categories of discrimination. And they're all standalone, so you could be sued for 1 or 2 or all 3 of them. Okay? So we need to know what they all are. The first one is called disparate treatment. And this is where somebody is being treated differently because they are in a protected class. So because they are male, or because they are female, or because of their race, or religion, or national origin, or sexual orientation in this state. Have to treat everybody the same. Disparate impact is a little bit trickier. It happens where you have a neutral employment policy, so it looks like it applies to everybody, but as you start putting it into play, one particular group is hit harder than another. We'll talk about these in a little more detail. And then the third one is harassment. We hear a lot about sexual harassment, but you can be in trouble. I always say this, you can harass somebody, which sounds like I'm encouraging that. You can be in trouble for harassing somebody based on any of the protected classes that they might be in. So what are these protected classes we've been talking about? Okay. On the federal side, the first one is race. How many people in here think that if you are a middle-aged white guy, you are out of luck and you're not protected? Oh, you guys listened to me last year. So, race encompasses whether you are white, or black, or Asian, or Native American, or any of those things. The second one is color. And color was included so that you could pick up situations where, for example, a darker-skinned person is discriminating against a lighter-skinned person. And you see that sometimes, particularly in African Americans, historically. Religion, national origin, we'll talk a little bit about what's included in that. If you happen to have like a surname that's associated with a particular national origin, that would be included in that category, even though you aren't anything particularly. Gender, male or female, both protected. Disability, age, protects people that are over 40. People that are under 40, sorry, out of luck for now. We also have in Washington State some additional protected classes. Of course, we incorporate all of those from the federal law, but we've added sexual orientation, marital status, and veteran status to our list of protected classes. One of the places that disparate treatment comes up, particularly in jobs that are fairly physical, is harder standards of testing than what is needed to be able to do the job. Now, we certainly want to make sure that whatever standards we're testing against are what is necessary to do the job, right? If you need to be able to carry a fire hose up a ladder or carry a person down a ladder, then we should test for that. You should have to be able to do that. But it needs to be the same for everybody. You got to give the same feedback to everybody. Sometimes employers or supervisors are afraid, because somebody's in a protected class, that if they are harsh on them and give them criticism, that they're going to get sued for that. There was a case where a woman was an attorney, actually, and she worked for Texaco. She happened to be African American. And she had been on maternity leave and then came back, and the supervisors got mad at her because she had been having a lot of visitors to her office behind closed doors that were predominantly black. And so they told her she was becoming the black matriarch of the company. Bad idea, right? So she went and she complained to the human resources folks and said, look, I think this is discriminatory. So that got back around to the supervisor, and they then decided, all right, no matter what happens, do not discipline her. If it gets really bad, come and see me, but otherwise, don't say anything because we're afraid we're going to get sued. And to some plaintiff lawyers' great enjoyment, they put all this in a memo. That's bad. Then they got to the point where they had to do layoffs. Well, guess what? Our person who hadn't been getting any feedback wasn't doing as well as everybody else, and so she was one of the people selected for layoff. And she sued. Imagine trying to explain that to the client as a lawyer. You purposely didn't do anything to this person while they were employed there because you were afraid of getting sued, and now you're getting sued because you didn't do anything to this person as far as constructive criticism. Treat everybody the same. If you are going to discipline people for being late, what was that you guys were saying? Doing checks on your truck?
Truck checks on Saturday. Something that they need to be doing.
Something they need to be doing?
Yeah.
If people don't do that, then everybody should get written up that breaks that rule,
That's right.
not just certain people. We didn't set that up ahead of time either. Okay, so what do? We use objective criteria. Okay? You've got a certain amount of time within which you have to do your truck check. Consistent consequences, similar feedback, similar opportunities for everybody. We don't make decisions based on somebody being in a protected class. So I want to talk now about some common mistakes that come up in each of these protected classes, because if we were going to cover them all in detail, we would be here for a really long time. Religion. People think that the only religions that are included within that protected class are the ones that we've heard about. Okay, you know, if you're a Catholic or you're a Baptist or Lutheran, whatever it might be. But that's not true. The test for religion is whether or not it's a closely held belief and it takes the place of religion in your life. So in the class that I teach up at Whitworth, I use the example often of Lawyers for the Lake. Okay? If I have a group that I belong to that's my religious belief and it's called Lawyers for the Lake, and we believe you have to take every August off and commune with nature, if that's a closely held belief and it takes the place of religion in my life, it counts even though none of you ever heard of it. Okay? If somebody says they are Christian, that's covered. Even atheists are covered because it's a closely held belief and it sits in that spot where religion would be. It's a little counterintuitive sometimes. Even if it's particularly unpopular, it would be covered. Now, a political group is not. If an employee has a particular religious practice that may conflict with a rule here or requirement, the district will attempt to accommodate that so long as it doesn't constitute an undue hardship. But unlike many areas of discrimination, if it's an undue hardship, then they don't have to accommodate that. Don't see that come up too often. So let's talk about this particular religion. A little bit of practice. Marcus, there's no Marcuses in here. This is a made-up Marcus, just in case. Belongs to a group called the World Church of the Creator, and this is a real organization, but it teaches white supremacy. And Marcus ends up on the front page of the Spokane Review, and he is holding up some materials that espouse the beliefs of his organization. Now, he also has about 8 people that work for him that are of mixed ethnicities. So the employer starts to panic, thinks, well, we can't have this person that believes in white supremacy be supervising people of different ethnicities. He might take action against them. So what do we think? Can the employer demote Marcus? Take away all of his subordinates? No?
Hasn't done anything at work. Unless he's done something.
Yeah, he's not done anything at work. So consensus is that he can't do anything? But it's horribly offensive. It's white supremacy. We're gonna let that go?
Right.
Yeah, we are. Okay. As distasteful as it is, the courts have said, because it's a religious belief and because it sits in the place of religion, it's protected. Now, that does not mean that person gets to show up at work and take any action or make comments or harass people because of their religion or that sort of thing. But it would still be protected. All right, national origin. There has been a, yes, sir.
I don't want to back up with you.
Okay, we just want to back up the slide, but we'll
That's
talk.
right. So one of the last things on there was reasonable accommodations needed.
Mhm.
What about for the people that work for him? They see that and they feel threatened. Can they ask for other supervisor or accommodations?
They could ask to be accommodated, but they would have to be able to point to
Prove
something
that-
that's happened, as opposed to just a
What
fear
they
that
saw.
something might happen. That'd be really tough from the employer's standpoint. Anybody else? Feel free to jump in anytime. Much more fun if you guys are talking and I'm not talking all the time. All right, so national origin. After 9/11, huge uptick in national origin claims. And if you were to go and read some of those cases of things that happened after that, it would roll your socks. So it's very broadly construed, that protected class of national origin. Okay? So you can see there, if you are a particular national origin, I happen to be part Norwegian and German, and so those things could count. You know, we've all heard those Norwegian jokes. If you are associated with somebody of a particular national origin, even though I'm not, that can count. If you have a surname, as we talked about, say you got married and I have a surname that is associated with Hispanics, and so somebody is then harassing me or discriminating against me because of that. And that's a little counterintuitive, isn't it? Would you think, well, wait a minute, Michelle, you're Norwegian. You're not a protected national origin. But if I had that last name, I would be. Even linguistic characteristics can count. So just keep in mind that's very broad. So here's our example. Jan's parents are from India, and his co-workers exclude him because they think that he is Middle Eastern, and that he affiliates with terrorists, and they blame his kind for the terrorist activities. You think that he can support a national origin claim even though he isn't Middle Eastern? Indian?
Yeah.
Yeah, he's being treated as though he is that national origin. All right, let's move into genders. You will be happy or unhappy to know that there are lots of ways that you can mistakenly discriminate against somebody based on their gender. Okay? And it protects both men and women. So we all need to be aware of that. So straight gender means that you are being treated differently because you're male or because you're female. Just straight up. Gender plus means that you are being treated differently because of your gender and some other attribute, like you have children. Gender stereotyping comes into play when either a male or a female doesn't meet what society normally thinks somebody in that gender should act like. Logistics. This is where bathrooms and such come in. Gotta have decent facilities for both genders. And you would think, well, of course you do, Michelle. But there have been cases where one gender has restrooms and locker rooms and the other gender does not. That was actually a firefighting case. Pregnancy, the fact that you might become pregnant, the fact that you are pregnant is protected. Equal pay, and then of course sexual harassment. Lots of things there. So let's talk about Jenny, who is a fabulous firefighter, paramedic. She is quick, physically fit, she's great with the patients, does an awesome job, but she's a little rough around the edges. Hair is always kind of disheveled, cusses a lot.
Melissa McCarthy.
What's that?
Melissa McCarthy.
There we go, Melissa McCarthy. Okay? So she applies for a promotion, but she doesn't get it because somebody says, you know, you really need to smooth out those edges a little bit, be a little more feminine, and then we'll consider you for promotion. What do you think?
I would just stuck with being more professional.
That you'd have just said you need to be more professional? Well, what if guys that are rough around the edges, they cuss, they comb their hair,
Equal.
they have to be professional too? Okay. Can an employer require that? Can we say, you know, you need to be a bit more girly? No, because it puts women or men, as the case may be, in a catch-22. I'll tell you this kind of the big case that came out of this area. There was a woman, she was an accountant, and she was an associate accountant, and she like single-handedly worked a deal with the Department of Defense to get like a $25 million contract for her accounting firm. So she's up for partnership. And they tell her you need to walk more femininely, talk more femininely, maybe take a class at charm school. I can show you some charm. No. And so they can give her a promotion. And the catch-22 is it's exactly those qualities of being rough and what have you that helped her to make the $25 million contract that they now won't make her a partner because she has. So which way is she supposed to go? And I don't want to put people in that position. So what of those category things that we looked at, which do you think this is? Gender stereotyping. Girls should be girly. Men should be manly. Never should they cross over, I guess. I mean, for me, it's all about, are you making money? You know, I don't care past that. Bring in money. Okay, so what if we have a firefighter who is in the early stages of pregnancy? And the generic captain, not anybody here, generic captain, says, you know what, I'm just worried that something's gonna happen to that baby if she's out there doing those difficult runs. So I think we're gonna put her on a desk. You gonna do something like that? No. No. It is not up to all of us to become doctors and decide whether or not somebody is okay to be doing their job, whether it's pregnancy or some other physical issue that's going on. The doctor says you can do the job. You either get to do the job or you have a fitness for duty. Yeah?
Can the captain get in trouble for expressing his concern and giving her the option?
Yes. Yep. Because it really ought to be up to that person to decide whether or not they have any physical condition that is going to impact their ability to do the job. We had one of the firefighting cases I was involved in a while ago, and I'm trying to be careful that I don't say too much so you can put anything together. Somebody had monovision. They go and see out of one eye. And the question was, can this person be a firefighter? They've got monovision. And the answer was yeah. There is nothing in the rules or regulations that say you can't drive with monovision or you can't otherwise operate equipment.
With something like that, can the employer require them to go get a clearance from the doctor?
Yes, absolutely. So you ask for release from the physician to do the job. If you're still uncertain, you could send for a fitness for duty evaluation to make sure they're really okay. But if they are, then they should be able to do the job, right? All right, disparate impact. Remember, this is our second category where we have a generic rule that looks like it applies to everybody the same, but turns out to be a built-in headwind for one group. In order for that type of rule to be valid, it has to be a predictor of job success. So let's say that I was a discriminatory employer and I wanted to have a fire district that was all women. And I know, because I'm an attorney, right, that I can't say only women can apply. So instead, I make a rule that says, in order to be part of my fire department, you have to weigh less than 135 pounds and be shorter than 5'6". I didn't say anything about women. What's going to happen as the applications start coming in? Men are going to be excluded at a disproportionate rate, right? Because you're more likely to be taller than 5'6" and more than 135 pounds.
So how does Hooters get away with it?
Good question. Do you know they fired a woman who was like 5'10" or 5'9" and weighed 125 pounds because she was overweight? I'm like, really? So, the real answer is that they don't. When they get sued, they pay up. Because, and I teach this class at Whitworth, right, called Employment Law for Business, and we talk about this. And almost every time I teach it, some group of guys say, we're going to go apply, Michelle. And then when we don't get the job, we'll all sue them and we'll all make money. But we never do.
But we could.
But we could.
Should we go through that application? I need some money. We'll relocate those.
Okay. So to get back to my all-female fire department, I could not have that rule unless I could establish that being female was a predictor of job success. That you had to be female in order to be a good firefighter, and we all know that's not the case. You don't have to be male, you don't have to be female. All right, here's another example. You guys probably read about this one in the newspaper a couple of years ago. Back on the East Coast, there was a fire department, and they had a pretty rigorous promotional exam that folks had to take. And so people studied for it, they gave the exam, but then a minority group did not do as well as another minority group and a majority group, which is interesting. So the fire department, because they were afraid that they were going to get sued, threw it out, said we're not going to count it. And the folks that passed, which were the majority group and another minority group, wait a minute, we studied really hard for that exam, and we passed it, and we ought to be able to be promoted. So they sued. Do you think the department ever saw that one coming? The people that passed sued. And so the court looked at the test and said, you know, there's nothing wrong with this test. It is a valid predictor of whether or not you're going to be a good supervisor, and you can't toss out a test just because you're afraid you're going to get sued. So they reinstated it. All right, so how do we make sure we don't run into this problem? We test for the things that you really have to do. We just don't make up rules like you have to be 135 pounds and 5'6". Okay? We test for the tasks that you really need to do. I mean, it used to be that, you know, whether it was police officers or other types of organizations, you had to do, you know, so many sit-ups or, you know, that sort of thing. But now we test for actual activities, like in Vista, you have to climb a pole in a certain amount of time. So, is it necessary to do the job? Do you need to have that skill to be successful? And is that the best way to test for it? One of the case examples of this, I'm trying to get the facts exactly right, it was for prison guards. And you had to be at least 5'2" and 160 pounds, I think it was. And so when people applied, of course, shorter men, weaker men, shorter women were being excluded at a higher rate. So the question became, do you need to be at least 5'2" and 160 pounds to be the prison guard? What do you think? Is that a predictor of success? Maybe? I mean, what do we really want? What do we want in our prison guards? Fit? You gotta be able to take down a prisoner, right? If there's a ruckus or something, you gotta be able to step in. Well, just because you're a certain height and weight doesn't mean you're gonna be able to do that. You could be a small person with a black belt, right? So if you need to be strong or you need to be fit, then let's test for that. Not these random height and weight requirements. Oh, well, there it is, 5'10", 180. All right, now let's get to harassment. There are some basic things you need to know. These are the elements of a harassment case. So the first thing is you're going to have unwelcome or offensive conduct or statements. Those statements have to be because of, and insert whatever the protected class is. Then it has to be sufficiently severe or pervasive to create a hostile environment. And then, of course, because the employer has all the money, we want to know that the employer is liable. So let's talk about what those mean. First off, you can harass on any of the protected classes: sexual orientation, religion, race, color, national origin, gender, disability, age, any of those. Okay? Your policy here prohibits discrimination on any of those protected classes as well. And if you are found to have been harassing somebody, bad things will happen. The way the law has developed is that an employer has an obligation to take prompt action reasonably designed to stop the harassment. We have to do something, and it has to be designed to make sure it stops. And it's just not worth it for you all to go there. Keep in mind that harassment isn't about wanting to have sex with somebody It's about exerting power. Okay? Keeping your thumb on somebody else. So how do we know if it's unwelcome? Well, sometimes it's obvious. If he gets smacked, that would probably be a good indicator, right? That would be direct. But it can also be indirect, where it's body language. Don't count on the person saying to you that I am offended. And although we see historically more cases of men harassing women, there are a lot of cases of women harassing men. Because women think that they won't get in trouble for it because it's not the norm. So all the ladies in the room, you gotta remember these rules apply as well. You can also have women harassing women and men harassing men. Sometimes conduct starts out welcome, it's all fine, nobody's offended, and then things shift. So be aware that you can have a change that occurs in the middle of the road. And I will tell you there has been a lot of cases where the person harassed just goes along. Okay? They go along to get along. They don't want to be that person. They don't want to make a complaint. So don't make assumptions about whether or not somebody's offended. And I think, in my experience, men are more likely to go along even than women are. No one cares what you intended. Okay? I want to say that again. No one cares what you intended. I have had tons of people come in and say, Michelle, I was only joking. I didn't mean anything by it. I wasn't trying to hurt anybody's feelings. I'm sorry. I'll take it back. No one cares. It's all about how it was received. Okay? So how do we know whether or not it is offensive? We look at it both subjectively and objectively. So was the person receiving the information offended? That's the subjective part. And then would a reasonable person, the same gender as, we'll use victim, be offended? So we want to make sure we weed out people that are just highly sensitive, and that's why we have the objective piece as well. Some examples of things that have occurred in cases that I have been involved in, and you might think to yourself, who would do that? Happens more than you would think. Some people are huggy. Okay? Doesn't happen in the workplace. A lot of tickling. Don't do that. Shoulder rubs, things like that. The kissing bandit. You think I'm making this stuff up. I only wish I were making this stuff up. We actually had a case, and this person was a general manager over several different restaurants, and he would randomly kiss people. He would go to these restaurants, walk up to one of the workers and kiss them. I mean, like smack on the lips. How do you defend that? I'm just asking you, how do you defend that? And we've all experienced those people who just feel the need to kind of rub up against somebody as they're going by, like there isn't enough room to get by. Don't do that either, please. All right, statements. You don't need to call people those things. Please, 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 please never use any gender-specific profanity. I can almost guarantee you that if you use the C word, it will result in somebody getting out their checkbook. Okay? Because that just does not fly. Somewhat similar for the B word. but not quite as, I don't know, I won't say serious, but automatic maybe. This is not a dating pool, okay? So don't be thinking that this is where you're gonna find the love of your life, because those can turn south real fast. Some employers have now love contracts. Can you believe that? A love contract. If you want to date somebody that you work with, you both have to sign this love contract. How awkward would that be? Yeah, that last statement there, that was another case. Somebody thought that they were really good.
So is that legit, a love contract?
They have been fairly successful in making sure that neither person then comes back and sues the employer.
Kind of like a prenup.
Kind of. For the benefit of the employer. Okay, I want to talk a minute about some of these other categories. For example, racial harassment. You know, the culture in our country, or portions of our country right now, is such that we have some issues going on that should not be. Plain and simple. And it's showing up in the workplaces. No names and nicknames, okay? No racial jokes, no posters. And believe it or not long ago, we had a noose in this area. Just when you think you've seen it all. Remember, male to male, female to male, all covered. There we go, male to male. You gotta wonder what caused that picture to happen, right? They're embarrassed about that forever. All right, I want to talk a bit about indirect harassment. Okay? And if you keep in mind that harassment is about power, then this sort of thing makes more sense. Okay? If you don't like a certain somebody because they're in a protected class and you know you can't overtly discriminate against them or make comments, people tend to resort to this. Okay? Give them the cold shoulder, just kind of ignore them, give them harsher treatment, worse assignments, things like that. Don't do any of that stuff either. What was the one I had recently? Person was just making up embarrassing stories about the other person and then telling it in the crowd. It was like, what are you doing?
Yeah.
Okay.
Savage.
So it has to be sufficiently severe or pervasive. So what we mean by that is if it is a really serious event, may only have to happen one time to meet this standard. Okay? I can promise you the one noose or the one grab is going to be enough to meet severe or pervasive. Usually if there is physical contact, it's considered severe or pervasive. On the other hand, if it is not physically based, but is comments, then it may take more of a pattern to be sufficiently severe or pervasive. So we're going to look at, okay, what happened? How often did it happen? What was the context? And I will tell you, if you ever had the opportunity to come and look at my evidence area, you would wonder what the heck goes on. People don't think. And let me just say, text messages are a plaintiff lawyer's best friend, because everybody thinks you can get rid of that stuff and you cannot get rid of that stuff. There are forensic companies out there who are making hundreds of thousands of dollars gathering stuff off of computers and phones that people think they got rid of. All right, so here's Fred and Susie. They're dating. Fred decides to break it off. Susie doesn't like that answer so much. She really wants to rekindle things, so she keeps pressing, asking for, let's just get together for a cup of coffee. I just want to talk to you. We can work this out, that kind of thing. We just went from a consensual relationship to a harassing relationship. That's how quick it can turn. I guess I should have asked you guys the question.
Yes.
Thank you for being there for me. All right, religious harassment. You don't get to attempt to convert any of your coworkers to your particular religious beliefs. Okay? You don't get to tease your coworkers about their religious beliefs. Just keep religion out. Okay, we kind of talked about that already. I did want to mention clothing. We know that there are particular national origins that have religious articles of clothing that go with it. You don't get to tease people about that. Such as that. Be aware that things can turn on you. Be aware that your coworkers may be offended. Be aware that if you are having a relationship or trying to have a relationship with someone, you may be perceived as showing favoritism. This next one is important. You can be found personally liable. I know I said, the employer has the money, and so everybody's trying to make the employer liable, but you can be sued in your individual capacity. And if you were found to have engaged in sexual harassment, somebody got a judgment, it lasts for 10 years, and it can be renewed for another 10. You don't get out of them in bankruptcy, so it will follow you around for the next 20 years. So as you're thinking about that joke or that comment, think, is it really that important to me? Not to mention, hard to pay a judgment if you're out of a job. Sexual orientation. This category is very, very broad, okay? Heterosexuality, homosexuality, bisexuality, gender expression or identity, okay? Very, very broad characteristics. And I will suggest to you that it's not going to be very long before, one way or the other, there is a national ruling on sexual orientation. It isn't going to impact us much because we already have it in this state, but there have already been court decisions coming out that saying sexual orientation is within the subset of gender, and so it's protected by Title VII, and that's a pretty big turn from what we've had in the past. All right. We have all heard these terms. We don't use them here. We watch for gender stereotyping. What is it that what they like to say about tough women, butch? We don't use that. Yes, sir.
I gotta thank you for lighting the loafers, because I wasn't me, that somebody said it and I actually knew what it meant because of this class.
All right, good. I'm glad to hear that. It used to be really, really common.
Yeah, yeah. It was an older guy that said it.
Yeah.
Lighting the loafers. You ever heard it? Oh.
Well, there is progress then.
Yeah. There you go.
All right, what are we gonna do about this situation here? If we have somebody that has gender dysphoria. And it could be that physically they're male, but they identify with female, or vice versa. In our example here, male but identifies as a female. Doesn't want to use the men's locker rooms, he wants to use the women's. And the women complain. What are we gonna do with that, especially in this state?
What's the law say in this town?
What's that?
What's the law say in the state? Do men just go in a female's locker?
The current rule is that you have to let the person use the bathroom that they identify with. Okay? There's a lot of controversy about that. I don't know if we'll see something change nationally. Yeah.
In the work setting though, can you claim that that creates an undue hardship for the female female employees, since now they feel uncomfortable using it, he's in there?
The only place undue hardship comes into play is in disability and religion. So we've not had the ability to use undue hardship as a defense to that issue. My husband and I were just talking about that, as to where that's gonna end up in the long term, if we're all gonna go to unisex bathrooms or what? All right, disability. There are 3 separate ways that you can meet the definition of disabled. Okay, the first one's pretty easy, right? You have a disability. Okay, got it. So it's medically diagnosable or cognizable. But if you have a history of a disability, let's say in the past you've had a heart attack, or you've had diabetes, or you've had something in the past, even though you're fine now, you can still meet the definition of disabled. Or if your employer treats you as though you are disabled, even though you're not, then you'll meet the definition of disabled. The reason for that is that there are so many stereotypes about disability. People assume that they know things. And so when they passed the Americans with Disabilities Act, they wanted to make sure and pick up all of those stereotypical perceptions. Age, you're over 40, woohoo, protected. There was a point in time where 40 seemed a long ways away. Now it seems a long ways away, but the other direction. So. No jokes related to age. I like that cartoon. Somebody sent me one today, and I wish I'd had time to bring it, but it said, all of the staff are suing you for, it's a woman talking to a man, as it turns out, but all the staff are suing you for sexual harassment, but you've never harassed me, so I'm suing you for discrimination. I thought it was really cute. Really cute cartoon. All right, so let's say Betty's 55, she's administrative staff, she loses her job, and then the person comes in who's 48. Is that age discrimination? That's a good question. At-will employment, does that mean that you can then discriminate against people? No.
If she did something wrong for getting fired.
What's that?
If she did something wrong to get herself fired, then it
Says
doesn't matter
without
if they hire
cause.
someone younger.
If she did something wrong, what if they made something up that she didn't really do something wrong? They just came up with some pretextual reason.
Then probably yes.
Yeah, then yes.
So if they let her go to hire somebody that's younger and they pay them less?
Okay. Then the question is, did the person get let go because of the dollars involved, the salary, or was it because of age? But the funky thing about age is that if you are over the age of 40 and the person that comes in is younger, that is the first part of that, what we call a prima facie case. That is the beginning of that. So then the employer's got to have a legitimate reason other than age for what they've done. And the employee then gets to prove that that's not true.
So when you say younger, 6 months younger, a year younger?
It just says younger.
But what if it was for monetary?
Now, if the employer says, look, we had to do it for monetary reasons, then that would be what we call a reasonable factor other than age. But what would be the smart thing to do if you really had somebody that was earning $60,000 a year and you had to drop it to 40?
Hire the other person that comes in with a different job description.
Offer them a pay cut.
Offer them a pay cut. You know, because if I say to you, we need to cut this salary and you can keep your job, but it's gonna be at 40,000, then clearly it wasn't an age issue, right? Because that person could have stayed if they were willing to make less money.
Is there, just a quick question, like, is there a time frame, say, for example, if they cut someone, normally if you're probably older in a position, you're gonna be making more top line profit, for example.
If you're older, did you say?
Yeah,
You're
say
making more
you're
money?
old, you know, for a position, you've been there a long time, and all that, okay, so they they cut your position. They said, okay, we're just gonna cut that position. Okay, so they don't have anybody in that position for a period of time, then they hire someone new for that position, younger, with less pay.
How much?
What's the time factor you can come back and say, hey, that was my position, you hired someone in that position. I wasn't called back or notified of that,
Yeah, there's,
even though I was qualified for it.
and there's no, like, timeline written in the law that says once you hit 6 months, you're good to go. Of course, the more time that goes by, the better off you are, but I wouldn't do anything in less than 6 months and consider myself anywhere near safe.
For
You just,
employers,
you
that's-
just changed the title though, right?
You know,
There was a material supervisor and today it's purchasing.
but you know what? Courts have gotten pretty smart. They can look past a title and say, okay, so what are you doing and what are you doing?
Description.
Because they've seen it all. Gotten pretty cagey. All right, I always like to talk a little bit about rumors. Don't start them, don't repeat them, don't carry them on. You've had issues in the past in fire districts with people talking about rumors. Okay? If it doesn't have anything to do with you, don't repeat it. Haters. Haters. Sounds like my teenage haters. All right, I want to talk to you about the information highway. Oh. I cannot even begin to tell you the number of cases where there are emails that have been sent, there are text messages that have been sent, there are text messages being sent on fire district, not this district, but fire district equipment. And that makes it next to impossible for me to defend the district or to help any of you, okay? Because when you're out there in writing doing things, you may be deleting things, the person on the other end isn't, and as I said before, there are companies out there that can suck all that information back. And they're making money doing that. If you wouldn't want that message on the front page of the Spokesman, don't send it. And if you think that you can look at internet pornography and that no one will ever know that you did, I've got at least a dozen people who have lost their jobs that would tell you otherwise. Dating sites. Did you know, what's the name of it? There's like sugar daddies and sugar mamas out there. These are sites for people that want people to have a lot of money, right? And they are scary people. They will set you up in a way and then claim that there's been a sexual assault, claim that there's been a rape, claim that there's been a promise that you were going to pay them money. So just be really careful. Social media. Ugh. Sometimes I think I should have retired just before this whole social media thing happened, because it's taken years off my life. But people think that they got their settings set so that they're limited. If you are talking about coworkers, if you are making sexually harassing comments, if you're making derogatory comments because of somebody's religion, it is going to come back and bite you, I can promise you. People like to talk bad about their supervisors, and they always find out. Always find out. Somebody blabs.
Isn't that funny?
What's that?
It really is, I've seen it multiple times.
Oh, yeah. People call in sick, and then they post to their Facebook page that they were at the movies or out at the lake. And I was like, really? So, just don't do that. Oh, here's some hints. Your opinions are yours, not the district's. Try not to be in your district gear in your pictures that you have on Facebook. Do not be talking about calls that you go on. I will tell you I don't think this was in this past year, but a couple of years ago, one of the firefighters posted on their Facebook about a call that they'd went on, and the call happened to involve the wife of the mayor, and it all got really ugly really fast. You can be legally liable for what you post. So just keep that in mind. You want to defame somebody or harass somebody. No supervisor-subordinate relationships, please, okay? I suppose it's possible that it would be the love of your life and you ride off into the sunset happily ever after, but odds are not. Okay? Why is it a bad idea? Everything you do with that employee going forward is suspect. If you're nice to them, it's favoritism. If you're mean to them, it's retaliation. Everybody gets to talk about your romantic skills or lack thereof at work. Everybody else thinks they need to date you. People lose respect for you. Management doubts you to leave. You could be sued by the employee that you're sleeping with, and you could be sued by the employee you're not sleeping with. Just not worth it. It is considered the most dangerous workplace activity. I mean, aside from the obvious fighting fires, right? Okay, so now we're going to talk about some cases. These are real cases, okay? These are real facts. So this particular person worked for a fire district. She was the public education specialist. She got reassigned, and then her position was eliminated because children like big uniforms with big men to fill them. That's what she was told. Can you believe that? I'm telling you, that's why I have a job. She had a reduction in pay, seniority, and benefits. She alleged also that she was harassed. They followed her, questioned her about her sick leave, gave her tasks outside of her job assignment, and more performance evaluations than other people had had. I'm going to jump ahead here. So what do you all think? Do we have an issue? Several of them, right? So what are our potential claims that we might have there?
Or treating her differently because she's a female.
In what way was she treated differently? That you
She was told that she wasn't manly enough to fill that role.
Okay. And she didn't get some of the same feedback that,
Or she got more feedback.
yeah, she got more performance evaluations, right, than everybody else got. Anything else anybody can see? That would be what, a gender discrimination, just for
Sure,
treatment?
We're supposed to read between the lines. I'm thinking she hooked up with somebody at the office.
She hooked up with somebody in the office and what? And it all worked out?
No. South.
Went
So-
south, okay.
Yep, they broke it off and then it went down
No,
from
there
there.
wasn't anything like that.
Right between the lines.
Yeah. What about harassment? You ever think harassment going on?
Question your sick leave.
Questioning your sick leave? They're not questioning anybody else's? Seems like they're maybe looking for a reason? That's Rosenbaum versus Southern Manatee Fire and Rescue from '97. Okay, second practice. Stand someone wanting to drive a fire truck. Goes to SEC, first in his class. But only women get to drive the fire trucks, and everybody knows we're better at it. Right? Okay. What do you think? Station in trouble? Yeah, you get to tell people everybody knows women are better drivers. All right, this one, 4 plaintiffs. So, Gender discrimination, sexual harassment, negligent supervision and retention. I didn't really tell you guys about what that is, but that's when you know that somebody's unfit for the workplace and you're not paying close enough attention to make sure that they stop what they're doing or they're out, okay? And outrage, that's when you engage in behavior that is so far outside the bounds of human decency that it's actionable. So here are some of the comments. These are the sexual harassment facts that occurred in that case. Bad, bad idea. Gender discrimination facts, they excluded some of the women from meetings, conversations, made comments inappropriate, dismissed the women's concerns, because it must be PMSing. They requested $1 million apiece. Look at what they got. Do you think any one of those people that engaged in those comments figured it was going to have a price tag like that attached to it? And I will tell you, if you get booted from a position for allegations of harassment, the ability to find another position is really limited. Employers don't want to take on that liability. Yes?
How do the courts come up with those specific numbers?
The courts don't, the juries do. And so you put on evidence of lost wages and emotional distress, and then a jury decides what's fair. Can you imagine what something like that would do to a district like this? Yeah, be done. Okay. Even the attorney got $700,000. I need one of these cases. Not against fire district, because I couldn't do that, but something else. All right, so what if we have a female manager that will take other females to dinner, but not guys because they're afraid of what it's going to look like?
Well, what does it
Well, they're afraid somebody's going to think that they got something going, you know? It's disparate treatment, isn't it? It's called avoidance discrimination. A lot of camaraderie is built and team building, and so you can't leave people out of that stuff. Just want to give all a word on professionalism. Good, bad, or indifferent, everything that you guys do out there ends up reflecting. At some point, somebody may have to put you on the stand, and you don't want to have some lawyer out there that's been able to go through your Facebook or go through your personal life and find things that are embarrassing. So just keep that in mind. Okay? You, especially at conferences and things like that, or trainings, you represent this district. So be professional. I know you all will be. Examples. We had one. It's surprising to me how many cases across the state. Thanks. I have questions, but there's two other things I want to mention. I forgot to put them in my slides. One is constructive discharge. There have been occasions where people know that they can't terminate someone, and so they decide to try and make their lives miserable, so they'll quit. Okay? Courts caught on to that pretty fast. That's called constructive discharge. If you ever want to see normally adult, rational people behaving like middle school age children, I've had adults that would like find somebody's car keys and hide them in a potted plant. So the person's wife had to come bring them another set of keys, but then just before she got there, then they'd take the keys out and put them back and play those kind of games. I'm like, are you kidding me? It's like middle school. So constructive discharge. If you make life so miserable that somebody quits, the law views it the same as if you fired them. But we don't want to do that. And then retaliation. if somebody tells you that they're offended, if somebody tells you they don't like your behavior, you may not retaliate against them, because that is a standalone cause of action, and they could sue you just for retaliation. So we don't do that as well. All right, now this is your free opportunity to ask me anything you want, and I'll do my best to give you correct answers. Yeah. Wow, nothing? Really? This is like free grow a lawyer time and nobody has anything?
It'll be at least one.
Everybody just wants to go home.
Maybe, right there.
All right, yes, sir.
What is it is considered discrimination? You bid for a government job, and the first thing you see is you're a minority, you get extra points. If you're female, you get extra points, female-owned business. If you're a veteran, you get extra points. If you're disabled, isn't that discrimination?
There are very limited opportunities for an employer to have an affirmative action plan, but they can only have them if they have what's called an underrepresentation. Now with veterans, we have decided that there would be credit for that as a thank you for service to the country. So that's where the veterans preference comes in. But as far as other minority groups, it would be to correct an underrepresentation, or it's probably an invalid plan. And they still have to be qualified for the job. Did I answer? Sort of.
Yeah, but people game the system.
People do.
Like all of a sudden, the wife is the president of the company, and the husband who runs the company is the vice president, for
Yes.
example.
Yep, yep,
So-
I've seen that happen. And somebody should challenge that, because that is exactly that gaming the system.
Yeah.
Anybody else? I knew I could count on it.
So the bathroom thing,
Yeah.
I just, for my own curiosity, is there any proof that they have to provide to choose differently one day versus the next? Or, I mean,
So far not. So far not. It's really unsettled though.
yeah. I mean, as an employer, is there any, I mean, you just have to kind of go with it basically at this point.
Yeah, what I've seen a lot of employers doing is creating a single bathroom. You know, that is a one person at a time kind of deal for anybody that's uncomfortable.
Yeah.
But you can't force
Yeah, I mean, I
the
just.
person that's gender dysphoric to use that bathroom.
Yeah.
And it's really tough because, for example, you know, Boeing, with their huge population, had so many workers going through gender reassignment surgery that they had a full policy and procedure on how they handled that. I mean, they had like 8, 10. So, yeah. All right. Thank you for having me. Eat all the cookies, and maybe we'll see you next year.
Yeah. Thank you.
Yeah.